this week the Supreme Court ruled on an issue that didn't get quite as much attention as perhaps it should have. In effect, the Supreme Court ruled that everyone deserves representation. Here to help us understand that ruling a little bit better is Elliot Mincberg. Elliot is Senior Fellow and Interim Senior Counsel at People for the American Way. He has a distinguished career in law and policy. He was former General Deputy Assistant Secretary for Congressional and Intergovernment Relations at the Department of Housing and Urban Development, also worked for the House Judiciary Committee, and he joins us now. Elliot, thanks for coming on the program.
Pleasure to be here.
So tell us a little bit about Evenwell versus Abbott.
Well, it really started as an attempt by far-right advocates to move the law in a pretty far right-wing direction, which, with respect to the Supreme Court, at least while it had the 5-4 majority that Justice Scalia helped make, has happened in a number of areas. This case in particular was an attempt to argue that under the principle of one person, one vote, you had to draw district lines and basically only count people who are eligible to or who actually do vote, which would result in a severe underrepresentation of people who are limited from voting because of restrictive voter registration rules, and generally would contradict the basic principle that everybody should be represented by our government, not just those who happen to vote in any one particular election. And,
so this is, just let me, if I can jump in for a second, Elliot,
Texas,
just to make sure that I and the audience grasp this, we are talking about whether congressional districts and their representation should be based on the number of people of voting age or the number of people altogether in that district, right?
Exactly.
So this ruling said, in effect, that no, people deserve to be represented based on the total population of a district, not just the population that happens to be of voting age.
Generally, that's right, although you have to pay attention to some of the details. What the court technically said was that it's okay for Texas, as every other state does, to base that apportionment on the total number of people, not just the people of voting age. The court didn't say what would happen if a state decided that it wanted to limit representation in that way, but it did say pretty clearly that it's proper to do it according to the entire population, and basically left for another day what happens in that other circumstance.
So is this basically, was this whole case another example of the right wing deciding that it was that somehow this is a way to suppress the vote of minorities? I mean, do minority-heavy districts tend to have more residents who are not of voting age, and is this kind of a way to weigh the scales in their favor?
I think that's right. It was an attempt both to increase the voting power of primarily white residents of really everywhere in the country, and also to move the law to the right in a very significant way by essentially suggesting that except for people of voting age or maybe who actually registered to vote, you don't count when it comes to representation, which, as Justice Ginsburg explained, was not the view that our founding fathers took when they set up the basic representational system.
Okay, so we had a fairly strong majority ruling. You know, we have a 4-4 court right now between liberals and conservatives. So the ruling in favor of this was, or on the right side of this was what, 6-2? Was that the final?
That's correct. It was, in a sense, it was unanimous because everybody agreed with the ultimate result, but 6 people joined in the opinion that Justice Ginsburg wrote, she and 5 others. Alito and Thomas concurred in the result, but didn't join the opinion. And their objections to the opinion, in theory, could be grounds for future litigation.
Okay, so there were different. In other words, there were common opinion. There was a common opinion, but different reasoning behind it. So, what was the majority reason, or the plurality reason, and what were the other reasons?
Well, it was a majority. The majority reason, Ginsburg and five other justices, basically said there just is no good reason based on constitutional text, history, and everything else to say that a state is required to only count voting age people when it sets up boundaries for districts. And by the way, these were not for federal House districts, but for state districts in a state election, state Senate, state House, et cetera, et cetera. And basically, the argument was there's just no strong support for that position in constitutional text, history, et cetera. And that opinion also suggested that that it would be wrong to do it any other way. That was where Alito and Thomas really disagreed with the opinion. Thomas suggesting that basically the court should stay out of reapportionment altogether, but agreed with the result because he agreed that states should be the ones who make the determination. And Alito essentially suggesting that he sort of bought a large part of the theory of the right wing plaintiffs in the case, that in fact there were good reasons to do reapportionment based on voting age population, but he agreed with the ultimate result because technically all the result said was that a state can, if it wants to, decide to make reapportionment decisions based on total population, not voting age population.
Okay, so are there likely to be more cases on this whole issue of proportional representation? Is this the end of the story, or are there going to be cases that deal with congressional districts, or are there any more assaults on proportional representation coming up?
Well, I think there could be some, but a lot depends on what states do. I think this case makes pretty clear that it would be very difficult to challenge any state that affirmatively says we want to do it based on total population. Where I think you're more likely to have potential litigation, and the people who brought this litigation have already said that, is if you run into a state that buys the right-wing theory and says, we want to just do the reapportionment based on voting age population. And if that happens, then people would challenge it, and that would get to court. And that, I think, is the most likely way that this issue could well come up again. And frankly, the composition of the Supreme Court is critical to that, as it is so many other issues, which is why this all ties back into the controversy on the Garland nomination.
Well, of course, and we're talking with Elliot Mincberg, who is, among other things, interim senior counsel for People for the American Way. And as long as you mention the Garland nomination, you have any thoughts there? I mean, obviously that's up in the air and caught in the sort of vortex of presidential and senatorial politics. But if you had to guess, Elliot, complete change of subject, you think that Merrick Garland is one day going to sit on the Supreme Court?
Well, I hope so. He happens actually to be a friend of mine. I've known him since high school, but I hope so. We don't know. We won't know for a while, I suspect. But what the controversy of his nomination shows, in conjunction with this case, is that what the Republicans are really objecting to is putting anybody on the court to take Scalia's seat who is not a hard-right judicial activist, as Scalia and Alito and Thomas, and in many cases Roberts and Kennedy are. They want to preserve that 5-4 right-wing activist majority that they've had in many cases. And that's, in large measure, what the Garland nomination has turned into. Merrick Garland is no far left-wing lawyer by no shape of the imagination. But he is certainly not a right-wing activist in the mold of Antonin Scalia, and that's what the right wing and the Republican Party wants desperately to have in place of Justice Scalia on the court.
You know, Elliot, I'm not a lawyer. My daughter is, but I'm not. But as a non-lawyer who's observed this process for a long time, I remember when Republicans, and they still do to a certain extent, and right-wingers complained about activist judges when they were really talking about judges who I thought were interpreting the law in the context of, appropriately, in the context of the Constitution. And now they seem to me to be extremely activist in the sense that they retrofit their rulings in many cases to the objective dictated by their ideology or their partisan political interests. You think I'm being unfair?
No, I think you've stated it exactly correctly. There's been a huge shift if you look at the history of the federal judiciary and the Supreme Court, beginning with the appointment of people like Scalia and Thomas and others. It's been very clear that there's an attempt to do a number of things that in some ways have succeeded. The whole so-called federalism revolution that restricted the power of Congress to pass laws. That was efforts on the right to throw out congressional laws, not at all on the left in any way, shape, or form. The Citizens United decision, which we think is clearly an activist right-wing decision that, again, limits the power of Congress and the states to enact common sense campaign finance reform. The reinvention of the Second Amendment that throws out state and potentially federal legislation that tries to do common sense gun safety restrictions. All of these are examples of what right-wing judicial activism have brought us in the last number of years, and that's in a lot of ways what this is all about. The objection to Merrick Garland is not that he has anything in his record that genuinely suggests that he's a left-wing activist. It's just not there. He is one of the more moderate and well-respected judges in the country, including by conservatives like Ken Starr and Miguel Estrada. What they're really objecting to is that he's not in the mold of Antonin Scalia, that he's not a far-right activist, and that's what this fight is about. And we certainly hope that people around the country will realize that and will pressure their senators to do the right thing and give Merrick Garland a hearing and a vote.
Yeah, I couldn't agree more. And by the way, I think in that litany of cases, I may be wrong, but I would think that the Voting Rights Act and their Supreme Court's actions on that belong in the litany of right-wing actions too. What do you think?
Absolutely. Another example of the right wing invalidating legislation passed by Congress to protect voting rights in this case.
All right. Well, listen, we've got a lot to keep track of with these guys and their abuses. So, Elliot Mincberg, senior interim counsel and senior fellow with the People for the American Way, thanks so much for coming on the program and talking about this with us.
You're very welcome. It was my pleasure.